Thank you, and good morning, just about. So, the Chief Inspector said earlier that there is no objection that the Latin American traders are part of a minority. So what I am focused on is whether their rights as a minority have been addressed. There are three ways in which international human rights law is relevant in this case. First, the general obligations that the state has agreed to respect and follow. Specifically, the UK in 2008 stated before the monitoring body of the International Covenant on Civil and Political Rights, quote, "The United Kingdom does not become party to a treaty unless satisfied that its domestic law and practice are consistent with its treaty obligations." Second, international human rights law is relevant to this case as incorporated human rights law. I'm referring to the European Convention of Human Rights, incorporated through the Human Rights Act. So also the case law that the European Court of Human Rights has, explaining and contextualizing the provisions of the European Convention of Human Rights, which means of the Human Rights Act, are very relevant today. And finally, as unincorporated human rights law, informing, interpreting and clarifying domestic law and practice. So the International Covenant on Civil and Political Rights, the United Nations Convention on the Elimination of All Forms of Racial Discrimination are texts that the UK has agreed to inform, contextualize and clarify its domestic law and practice. And I would like to draw the attention to the Supreme Court's judgment in Muhan versus Lord Advocate and in R on the application of JS versus Secretary of State for Work and Pensions. These cases both provide a detailed review of the utility of international human rights law in domestic judicial review challenges. And again, they follow what I have said earlier. The Court has said that where international obligations have been incorporated expressly into domestic law by an Act of Parliament, they become part of domestic law. The Human Rights Act 1998 incorporates into UK law the rights recognised in the European Convention of Human Rights, and through Section 2, Strasbourg jurisprudence interpreting the Convention must be taken into account. The Supreme Court has actually noted, quote, "It is consistent with the intention of Parliament in enacting Human Rights Act 1998 that our courts follow a clear and consistent line of decisions of the Strasbourg Court, whose effect is not inconsistent with some fundamental, substantive or procedural aspect, and whose reasoning does not appear to overlook or misunderstand some argument or point of principle." The European Convention of Human Rights protects against discrimination on the basis of race. Here I argue that there has been discrimination on the basis of race. The European Convention of Human Rights and the Court include in this discrimination both direct and indirect discrimination. Here I argue that there has been indirect discrimination. The European Court of Human Rights has recognised the right to cultural identity through Article 8. Here I claim that there has been a violation of the right to cultural identity. In addition, the Court has observed in Chapman case that there seems to be, quote, "an emerging international consensus recognising the special needs of minorities and an obligation to protect their security, identity and lifestyle." So I argue that non-discrimination provisions in the domestic law also include specific provisions on rights of minorities and have to be protected by international law and have to be contextualised and clarified and applied in this spirit. And this is the indirect effect of international law, the final category I talked about at the beginning. In Muhan, Lord JSC elaborated on this point, quote, "The Convention is not to be read as if it were a Westminster or a Holyrood statute. It is an instrument of international law, to be interpreted according to that system's markedly distinct canons of interpretation." And he refers to Articles 31 and 32 of the Vienna Convention of the Law of the Treaties. So, and this provision, this treaty says that a relevant rule of international law applicable between the parties must be taken into account when interpreting the rights. So the Equality Act and the Public Sector Equality Duty and other domestic laws have to be interpreted in line with the minority provisions and in line with the non-discrimination provisions. I believe that the Equality Act obliges state and emanations of state, such as local councils, to take steps to meet the needs of people with certain protected characteristics, to take steps to meet the needs, not just not to intervene with their rights, to take positive steps. And also to encourage people with certain protected characteristics, such as race, to participate in public life or in other activities where the participation is disproportionately low. So take steps for the implementation of the rights as much as for their participation. And the Human and Equality Rights Commission, in elaborating on the law and in elaborating on the duty of the state and its emanations, has actually said that if a public authority does not consider how a function can affect different groups in different ways, the function may not meet its own objectives. So the authority would have to consider clearly how a function can affect different groups in different ways, and not treat the whole traders as only one group. Equally, the Human and Equality Rights Commission has said having due regard is not a matter of box ticking. The duty must be exercised in substance, with rigour, and with an open mind, in such a way that it influences the final decision. There should be evidence of a structured attempt to focus on the details of equality issues. And I have with me, apologies, the guide. The Essential Guide to the Public Sector Equality Duty by Equality and Human Rights Commission. It's here. So the third impact assessment in June 2017 frames indeed more explicitly the assessment under the obligations created by the Equality Act and Public Sector Equality Duty, and emphasises more than the 2015 assessment that they are considering the rights of minorities. However, this proves, if anything, that these issues were not taken into account in the previous impact assessments and discussions. I believe that this case started in, was it 2004, 2005. So we're now in 2017, where really we start discussing the minority, the specific aspects of the specific minority and the implications that the Council's decision will have on this minority. I can understand that indeed we improve as time goes by, but oh my God, this is rather a slow improvement. In 2017, after 12 years of discussing these issues, finally these issues are introduced in the discussion. So now I'm going to move on to the obligation of the UK. Very quickly, the UK has a negative obligation to protect minority rights, but also a positive obligation to protect minority rights. In this positive obligation has been highlighted and confirmed in several cases of the European Court of Human Rights, including the Chapman case. The UN Human Rights Committee has clarified what this means, and the committee has said that Article 27 of the International Covenant on Civil and Political Rights, the rights recognized and established there are conferred on individuals belonging to minority groups as distinct from and additional to all other rights, which as individuals, in common with everyone else, are already entitled to enjoy. So no, minorities do not, and minority and international minorities does not create new rights that the domestic law to what the domestic law already recognizes. But it pushes forward the interpretation of and the correct application of these general rights in order to address the specific minority needs and concerns. The UN Committee on the Elimination of All Forms of Racial Discrimination has clarified that we're talking about specific rights pertaining to certain categories of persons or community, such as, for example, the rights of persons belonging to minorities. Such rights are permanent rights, recognized as such in human rights instruments. And on top of these specific permanent rights, we can also have temporary special rights, but on top of these specific permanent rights, special temporary rights taken for the sole purpose of securing adequate advancement of certain racial or ethnic groups. And it is not up to the state and its emanations to decide whether to have these special rights if the circumstances warrant them. It is an obligation of the state to take this special additional protection. So this clarifies the issues in our report about negative and positive protection. Let me move to the right to culture. Sorry, just on my previous point, just to conclude, if the Council not stopping the Latin American community from going somewhere else and creating another hub, cultural hub, is not enough. The Council has at least not to put obstacles in the existing cultural hub. It has been created, organically or not, but it has been created and it exists. And if this stops existing, this is an obstacle that the Council, an emanation of the state, puts to this minority to exercise their rights. In addition, the Council has to take positive, permanent measures to protect the members of this minority to exercise their rights. So let me move to the content of the rights. First of all, the right to culture. Culture is understood to have a broad meaning. It manifests itself in many forms and should be interpreted broadly. So it includes the right to culture, includes the right to access to minority culture, the right to practice one's culture, the right to teach one's culture to the children, the right to allow for cultural activities, the right to allow the non-minority population to get to know more the elements of one's minority culture. The Seven Sisters Market, as I understand and as I have seen, functions as an informal cultural centre for London's Latin American families, Cafes and stalls are a meeting point. The children go there and are taught their language. They go there and play. Latin American people go there and eat their local food. They dance their local dances. They listen to their local music. It essentially provides a sense of belonging to the London Latin American community. There isn't at the moment any other cultural hub like this in North London. So this means that if they don't have this hub, they will have to start all over from scratch, or they will not have a cultural centre, informal centre anymore. The negative impact has been accepted by the Council itself in the 2012 Planning Equality Impact Assessment that concluded that the loss of the existing shops and market poses a potential threat to the cultural connections of the London Latin American community, but no further discussion than this. The Court of Appeal also found that the Council had failed to give due regard to the need to promote equality of opportunity in this case. So what I argue is that the obstacles that to the right of the London Latin American minority to their culture arising from the compulsory purchase order are not shared with the rest of the traders, the rest of the population. And as such, the redevelopment of the market in the way it is laid down at the moment has an unequal detrimental effect on the right of the London Latin American minority members to the culture. So this constitutes indirect discrimination. So there is no formal discriminatory distinction that is made between the Latin American community and the other traders, but the effects of this initiative, the way it is at the moment, means that the Latin American community are going to be detrimentally affected a lot more than other traders. Both the 2012 and 2015 equality impact assessments failed to recognise the extent to which the redevelopment will affect the cultural rights of the London Latin American community. And both assessments did not identify the unlawful discrimination. So we're not talking about the extent to which, we're not talking about the decision that the Council took. We're talking about the process and the criteria and the concerns that the Council had in reaching this decision. And it seems that the minority rights and the right to culture of these Latin American traders were not taken into account at any length. Also, the additional measures that the Council has required of the developer do not meet the requirements to take specific permanent measures to protect the members of minorities. The additional measures, including in the planning permission, which require payments to retailers to facilitate their relocation to the temporary area, and also the appointment of a market facilitator, are insufficient to protect the London Latin American community against the violation of the right to culture. The measures do not ensure the suitability of the temporary accommodation for cultural activities. We don't know whether they'll be able to continue with their cultural activities. The Council has not required the developer to provide guarantees for the continuation of the cultural activities. There are no guarantees that the Latin American traders will be grouped together in the temporary relocation. There are no guarantees that the temporary market will be able to become a hub for cultural activities. There are no guarantees whether there's going to be space for the children to play and engage in their cultural activities. Also, the reduction in market rents by 30% for 18 months also does not sufficiently reverse the obstacles to the enjoyment of the right to culture of the London Latin American community. This measure merely delays the closure of the Latin American market stalls. Permanent, specific measures have to be taken to adequately protect the cultural rights of this minority. Finally, the measure that there's going to be a market facilitator appointed by the developer to ensure that the traders will return, again, does not adequately address the indirect discrimination. The facilitator's functions are very generic. Such functions include the provision of assistance to traders in finding suitable alternative employment. There are no guarantees that the Latin American traders will be able to continue operating at the market, no guarantees of a result that would protect the rights of this minority. Finally, the monitoring that was discussed, so the promise that community engagement and diversity monitoring will identify if the Latin American traders cease to operate, is not adequate. This is an insufficient measure. We're talking about monitoring whether something, a detrimental effect has taken place or not. Measures have to be specific in preventing from these detrimental effects. So this is about the right to culture. And now I move to the right to effective participation and consultation. The appropriate procedural protections to give participation effective, to ensure effective participation, have not been taken. So international law does not just require participation, it requires effective participation. It requires genuine consultations. It requires adequate and reasonable notice for all affected persons. It requires all information in English and Spanish in time for the traders to discuss it and reach a decision. And this participation has to be effective and has to take place in all aspects of the project before the project is finalized, before the decision is taken. Very interestingly, the monitoring body of the Framework Convention on National Minorities, a treaty that is binding to the UK, called on the authorities of the UK to ensure, quote, that support for cultural activities of all national and ethnic minorities is increased across the country, and suggested that political participation of minority representatives in relevant decision-making processes is crucial for their interests to be heard. So effective participation has to be meaningful and not symbolic, and this is what the Equality and Human Rights Commission, this is how it has interpreted domestic law. Steps to facilitate formal participation, the Commission has said, are insufficient. States must ensure that participation has a substantial influence on the decisions which are taken, so that there is, as far as possible, shared ownership of these decisions. So, from what I understand, most of the Spanish translations of the documents forming the Statement of Reasons and appendices were provided to the Latin American traders after the deadline for public submissions on the proposed compulsory land acquisition had lapsed, and this is despite the Seven Sisters market traders expressing repeatedly their concern about this. The Council has not provided additional positive and specific measures to facilitate the effective participation of this specific community, of this specific minority, before progressing with a compulsory acquisition order. The Council has not explored all feasible alternatives in consultation with the minority. I heard that originally there was a plan that was put forward in the very early days. There was a plan that was put forward by the Latin American traders. I think Carlos, I can't remember his surname, I'm sorry, says this in his testimony, but this was never taken into account, this was never discussed, this was never addressed. Other suggestions seem to have been on the table and discussed at length. We also heard in the first day, and I saw that by video, that the meetings would become quite intimidating, and we also had, we heard that from the Latin American traders themselves, and that the traders did not feel comfortable with discussions and did not feel that they were heard. Emails were sent, and somebody else, America sent an email talking about formal participation. The addressee of the email said, well, you talk to somebody else. Somebody else never answered the email. The Council statement of reason is silent on the possible discriminatory impact of the compulsory purchase order, thus suggesting no consideration of the indirect discrimination and on the right to participation. And then I move to balancing of rights. So there is discussion about the wider good, the public interest. And my understanding is that the Council claims that this is for the public interest. And, maybe there is going to be some indirect discrimination against this minority, but this is for the wider good. This is not, you might be surprised to hear that this is not an exception. This is something that we hear a lot in a lot of states and in a lot of judicial and semi-judicial bodies. Minority rights are there to protect people who are very vulnerable. And because they are more vulnerable than the rest of the population, their concerns and their needs have to be taken into account more than the rest of the population. So in balancing rights, one has to give extra weight to the rights of vulnerable persons, including specific minorities, and in this case, the Latin American traders. Restrictions to minority rights happen, but restrictions have to be absolutely necessary and proportionate. And the restrictions have to be taken after discussion about whether it is possible to avoid them, or at least to minimize them. And this is a very famous case, Loveless against Canada. There, the International Committee concluded that the state's actions must have an objective and reasonable justification, be consistent with other ICCPR provisions, and be absolutely necessary. And the restriction must be absolutely necessary to promote the legitimate aim. The Human Rights Committee has said that where economic development projects may harm minority rights, the state must consult with the minority in question, and if the project poses a serious threat to minority rights, the development should be amended or even stopped. And this is the Lubicon Lake Band versus Canada. So, in balancing the rights of minorities, the state must give special weight to minority rights in view of their vulnerability. This is confirmed in Chapman. This is confirmed by the UN Human Rights Committee in General Comment 23. Therefore, the restriction of the minority rights of the members of the Latin American community as a result of the compulsory acquisition order cannot be merely justified in the name of the public good and the general right to development of the local population, even if we agree, and I heard earlier on that, we don't all agree on that, but even if we did agree on that. Okay, so in concluding, what I argue is, first of all, international human rights law is relevant in this case, on its own merits, and on complementing, interpreting, and contextualizing existing domestic law. Secondly, the compulsory purchase order will disproportionately impact on the Latin American traders as a minority. The existing additional measures, the recent additional measures, do not go at a sufficient way in minimizing these negative impacts. The Council has not given additional weight to the rights of the Seven Sisters market traders as members of the minority. This is inconsistent with the UK's obligations and the obligations of all its public bodies. In this, the way the purchase order stands at the moment, it violates the rights of this minority to culture, and it also has violated the rights of this minority to effective participation. Thank you.
I just have one question. I think your presentation has been quite comprehensive. And my question is this. What would happen if local authorities don't take into account these standards you just explained, and things go ahead? The Secretary of State confirms the CPO, and the minorities are affected in the possible way that has been described. What would happen with the UK and its international obligations? What is it risking?
Well, the first reason why it is risky is because the UK and the councils and all the bodies of the state are there to satisfy the and ensure the rights of all persons living within the UK and their potential to develop and lead a happy and fulfilling life. This is obviously not the case here. So, you know, the rights of a majority, if this is the case, and we heard that it may not be the case, but even if it is the case, the rights of a majority completely trump the rights of a minority, and no due regard has been given to these people. So first of all, you know, these are persons who live in the UK and who have the expectation from the UK state and the local authorities to ensure that they can lead their lives in a fulfilling way. Secondly, if I was the lawyer of if I was working with the lawyers of this minority, I would of course go to the European Court of Human Rights, and I would of course go to the international bodies, and of course the international bodies are, as you know, they have already done so in other cases and in general, would criticise the UK for not respecting the rights that the state has itself said that they respect. So it is going to be harmful to the reputation of the state.
Many thanks. I have concluded with my chief examination. Thank you.
Thank you. Mr. Corner, do you wish to ask questions of this witness?
No, sir, thank you very much. Professor Xanthaki is perfectly entitled to her views. We've heard a great deal of detailed evidence about the facts in this case, in respect of which she's not giving direct evidence, and so I've no cross-examination in relation to matters of fact, and in relation to matters of law, those are matters for submission. Thank you very much for the opportunity. And thank you, Professor.
Well, it wasn't a question.
No, but
No.
I would like to believe that what I said was not, you know, and I made quite a lot of discussion about, you know, it was not my personal views. You know, I referred to the law, so it was not just my fact, just my views. Thank you.
I understand. No, I don't have any further questions for you, but thank you very much indeed for coming to give us your evidence.